This is credit acceptance versus Megan Pratt and Dylan Herman. The claim is for quite a bit of money, $12,762.27 plus cost, interest, and attorney's fees. A default judgment entered in this matter. That was entered on December 9th. The defendant filed a motion to set aside that default on date stamped December 10th. So it was within 21 days. She said, I did not answer on time because I thought I can't tell what that says. Looks like it says 811 business days, not
should say 21 business.
21 business days, not calendar days. I made an attempt to answer, but I was told there wasn't a specific paper. So I returned home to both my wife and I could write out our answers. So that is from Dylan Herman.
There's more than just that.
Then they filed a more extensive answer regarding the default. Plaintiff's response is the court rule that says the two factors under the motion to set aside a default judgment was 2.603. They have to show good cause, D1. You have to show good cause or reasonable excuse for failing to respond to the lawsuit, and you have to provide a meritorious defense to the action required. Credit Acceptance Corporation lent you the money to buy a car, and they're the lender. And in your answer, you are raising issues regarding the car, and these are always bought as is. And then you also indicate that you are using SSI as your means of income, and you're right, they can't seize or garnish that. You also make some other veiled references that they took too many months, which would be a violation of the statute of limitations, and I don't find that's the case. So, Ms. Nonis Hartman, you're the plaintiff. Thank you for filing a responsive brief to their motion. You wish to speak to that further?
Judge, just to really drill home, they don't present any reasonable excuse. They both admit that they were served and that they just didn't know what to do or misunderstood, which the summons clearly tells them what they need to do. So ignorance is no excuse, especially when it was explained to them on the summons. Further, technically the answers, I guess, that you could say that they filed shouldn't even be applicable because they weren't granted the opportunity to file an answer. But even stating that, as you stated, they don't present a meritorious defense to the claim. So their claim and their motion is required to be denied under the court rules.
Why don't you speak to that further?
Sure. Which portion? Their defenses or their alleged defenses?
Yes.
So
yes.
As I stated, and as you alliterated, Judge, they first kind of contemplate issues with the dealership or the car, which again, this was financer, it's not the dealership, so they're not responsible for whatever issues they may have had with the dealership. A vehicle is purchased as is, so again, they don't have any liability as it comes to the vehicle itself. They basically gave them the money to buy the car, and that's where the liability comes in, that they just owe plaintiff the money. So unfortunately, it fails there. A couple other things I noticed in their response was that they stated they just couldn't afford it. It's because they're on SSI, which again, unfortunately, is not a valid legal defense. They stated something about frustration of purpose in the 777 rule, which I can deny flat out that that's incorrect because I have their file up and there was no violation of any FDCPA issues. And again, the time to do that would have been when they responded to the complaint, which they failed to do. They admitted they failed to do, and there was no reasonable excuse under the court rules. So both it fails on the first prong, which in turn it fails on the second prong. So therefore they haven't met the burdens under the court rules.
All right, that's a expansion of what was in their brief. The lawsuit was filed on September 16th. It was served on each of you on November 3rd. You have 21 days from November 3rd to file a answer. The summons says on its face in big black letters, "You have been sued. You have 21 days to file a complaint." And then it goes on to file an answer. So they allege, A, that you didn't cite a good reason for not answering, and more importantly, nothing in your response sets out a defense to the fact that you owe this debt. So either of you wish to speak to that?
Yes, so Your Honor, it does say the 21 days. I have the summons here and the envelope that the gentleman gave me. And I did not know, like, on that day, like what day it was, I guess. I knew that day, obviously, what day it was, but later on, I'm like, okay, were we served on Monday, Tuesday, Wednesday? There's nothing here that says what day we were actually served. And then the courthouse themselves were closed for the holidays, for Thanksgiving and everything as well. And we did come in twice to respond to this, because it also says under you have 21 days, it says you must file a written answer with the court and serve a copy on the other party or take other lawful action with the court. So it says if you do not answer, blah, blah, blah. So we came in and we asked for that written answer form. And that's when we were made aware that, no, you can't use a form. Just go back and write it on paper. I'm like, okay. So then that took another day to come back and write it. Then we called and asked a question about it, and we spoke to a lady there. And then the holidays for Thanksgiving and stuff, and then we called because we were coming in that first week of December, and that's when we found out that there was already a default judgment being signed, and so she told me to come in anyways and just file this new motion.
Well, it didn't actually get signed until December 9th, which was 30
before my motion.
34 days after you were served. But more importantly, you don't have a defense to the fact that you owe the debt. Your complaints are with the auto dealership, and this is the finance company that lent you the money. Now, you're contending that they haven't really lost anything.
So the vehicle was returned. The vehicle was returned to them. It was attempted to be returned to them immediately at purchase multiple times. They refused to cancel out the loan or work with us on the loan. And then later on, the vehicle was not usable in any way, shape, or form within 30 days of me purchasing. There was electrical issues with the vehicle. There was multiple times that the radiator along with the alternator had to be replaced. It was not a safe vehicle at all, which obviously that goes back on whoever sold it, the company that sold it to us. But we had contacted the lender to cancel out that loan multiple times, and they told me just to keep paying on it. They put me on payment plans. They kept telling me like it'll all work out and call us if you need this. So then we took it into another place, and then finally the vehicle got totaled out by my insurance company, which is how they ended up back with the vehicle. But then they said I did not hit a deer according to them.
Totaled out. There was an accident with it?
Yes.
Well, what you're proposing doesn't work. If I go to First National Bank and I borrow $10,000 to buy a car, I drive it off the lot, and I don't like it or it's got issues, and I call the bank and say, hey, I want you to use my $10,000 loan because I don't like this car. And by the way, I want to just go take it back and give it back to the car dealership. They won't take it back. You sold it, you bought it as is at high interest rates. The auto dealerships are in the business of doing this, and I see poor hapless car purchasers like you in this situation all the time. You're paying for a dead horse. You're paying for a car you no longer have. But apparently the insurance company must have totaled it and given you some sort of a check. I don't know
the
where
check
that
was
money.
given. There was no check given. They worked directly with credit acceptance. So I honestly am not sure what happened at that point. I believe that it was credit, somewhere between the two. They denied that I hit the deer, but they did, agreed that the vehicle was no longer usable. And then credit acceptance got the vehicle from the insurance company and they auctioned it off.
Credit acceptance did or the car dealer
Correct.
did?
Credit acceptance.
Credit acceptance auctioned it off.
All right, well, that's what happens. Can you advise regarding that, Ms. Hartman?
Yeah, so as to their story, I don't see any justification for the story, but the car was repossessed and it was sold at auction, and whatever the amount at auction brought in, it was applied to their balance, and there was a deficiency that was owed.
This happens about 100 times a year to me here in St. Joe County. Somebody buys a car from a car dealership. The car has a high price, it has a high interest rate. The lender and the car dealer are taking risk to sell the car to people who don't have a lot of money. Then they get repossessed. They sell the car for substantially less than it was paid for. Let's say the car is worth $10,000. You paid $12,000 for it. The car breaks. You made a few payments on it. The car gets repossessed. They sell it for $4,000. Somebody washes it, puts it on the lot and sells it next time for $6,000. They apply $4,000 to your $12,000 loan and you still owe $8,000 for a car that you don't have anymore. I don't have to like it, but that's how much of this works. So, two issues.
So
You don't have a legitimate.
the vehicle was a hand-in, it was on a past lane, it was a hand-in. They did not come here to repossess the vehicle. In fact, my insurance company could not get them to even pick up their vehicle. And finally, that's when it was, they called me or asking why I didn't have where the vehicle was, wherever my payment is. And I'm like, well, it was given to the insurance company like you guys wanted, and they've been trying to get you guys to come pick it up. So they actually took the vehicle from the insurance company after a longer period of time. And I believe it was taken from a parking lot, a locked in parking lot that the insurance company put the vehicle at, because they didn't even know what to do with the vehicle, because not only did I not want the vehicle, but neither did credit acceptance at that time.
Okay.
All right. So what do you want to happen? They just write off this substantial debt? They don't get anything?
Well, as of right now, and we tried to pay on it before everything happened. The vehicle was not in any way, shape, or form drivable or salvageable. They refused the vehicle, so they knew that the vehicle wasn't worth anything. And then it was auctioned off yes, a substantial amount, way lower than the rest of the loan. But what payments I don't understand how I'm supposed to pay for this. The SSI that we have are for 2 deaf children, and that is our only income, besides for the fact that my husband does go to school. So I guess you could take his school loan away. I mean, I'm not sure.
Well, they can't do that either. The fact that you don't have money is not a defense to the fact that you owe money. So they're not going to take your SSI. They're not going to take his school loan payments, but your circumstances could change. You purchased this car, which is a 2013 Chrysler Town and Country. The car was $12,838. you financed at 22.99%. Loan sharks used to charge 6. This is an extremely high interest rate. This 11-year-old car, you had $7,390 worth of finance charges on it. And no one forced you to sign that agreement. And you signed it, and it's a contract, and it binds you to the terms of the contract. And it clearly says this vehicle is sold as is. And so, as I said, I see this dozens of times a year. You also apparently purchased some sort of extended warranty for an additional $2,000. I don't know what the status of that is, but the company was Gazelle Auto in Sturgis. This plaintiff is simply the people that lent you the money to buy the car. And so when you defaulted on the loan, they repossessed the car, they sold it. And so I find you have not stated a legitimate reason for failing to appear, and there is no valid defense. It's an unpleasant, big, ugly, bitter pill, but the motion is denied.
So
You
they
still
also
owe
says
the-
under the civil case that there is no other pending or resolved civil action arising out of the same transaction or occurrence as alleged in the complaint. And that's the other thing. There is and there was another lawsuit against credit acceptance, not for just this vehicle that I had, but also a prior vehicle many years back that the other attorney, I can bring that up or find the paper and send that to you, already closed out, and I will actually be receiving a settlement back from them.
That's a
Based off
different lawsuit, ma'am. That's not relevant to this
Yeah,
case.
that's not this case.
Even though this vehicle was included?
No, they
In
would
the
be
earlier
two separate
lawsuit?
debts.
You're saying this vehicle was included in an earlier
Correct.
lawsuit?
Yes, Your Honor.
Judge, I have been working credit acceptance files for at least 10 years. They don't combine cars. They don't combine debts. Each debt and each car is separate and distinct, especially if it's in two different law firms. So whatever lawsuit she's referring to or whatever attorney's office she's referring to is not relevant and very distinct from the debt for which we're here for today. I mean, I can't go and say another lawsuit was filed for another car that's not my law firm. Like, I can't put that on the summons. It's not the same car. It's not the same debt.
It's the same car and the same debt. It's due to the fact that I was overcharged with interest and you guys were sued for the wrong charges that all of us have received on
Judge,
both
we're
loans.
going around in
All right,
circles
all right,
here.
all right.
Are we done?
I don't see another credit acceptance case.
Through Lantern Attorneys, Lebanon and Keller, they
Well,
have
who
actually my
sued,
settlement.
who sued you?
I was not sued. We all there is a sue on credit acceptance, and that was already had just actually went through,
Yeah.
and that
All right,
included
that's-
both of my vehicle loans.
All right, that's not relevant to this. She's correct. There was no other lawsuit that included this vehicle in it.
That included the vehicle loan, and they just offered me a settlement on that vehicle loan that I have already accepted.
All right, good. That's a different vehicle.
No,
All right. Well, you haven't pled it. Yeah, I don't have a file number. I don't have anything. It's like, oh, by the way, there was another lawsuit with such and such and such and such. You have a right to appeal this, but I found that you have not complied with the court rule that would allow this default judgment to be set aside. So this matter is completed. I've got about 20 people waiting. You can appeal this. You can seek further legal assistance, but you signed this contract, which was very onerous, and you're bound by the terms of it. I don't have to like it, but that's the way it is.
Thanks, Judge.
Okay.